SJC-11969, the Drummer Boy Homes Association, Inc., v. Carolyn P. Britton and Randy A. Britton.
You may all be seated, except for Mr. Moriarty.
Thank you, Your Honor. May it please the court?
Why don't you wait a moment until
Very
we're
well,
all
Your Honor.
scheduled, we can get the timers set, and now you can begin. Thank you.
May it please the court. Thomas Moriarty for the Plaintiff Drummer Boy Homes Association, Incorporated. Your Honors, the appeals court decision should be reversed in this instance because a 6-month priority lien is created pursuant to General Law, Chapter 6, 183A, Section 6C, each time a condominium association institutes an action to enforce its lien for unpaid common area expenses.
So what does that mean? You'd always have a lien. It's a question of whether or not it takes priority over the first mortgage.
Correct, Your Honor. The question...
So you're basically saying that the condominium association trumps the first mortgage? Why?
Only in certain circumstances, but yes, because the statute provides for that remedy.
It's not so clear that the statute provides for that.
Well, it's undisputed that the statute provides a 6-month priority in connection with filing a complaint. No party disputes that. The question in this case is whether the statute would allow an association to subsequently file a complaint, and that perfects an additional 6-month priority. So the issue in this case is whether an association is limited to one priority lien in connection with the filing of a complaint. It's our position that the statute does not control, in the first instance, whether an association has a right to file successive actions. That is controlled by other principles of law which we have briefed. It is not claim splitting. It is not prohibited that where an obligation is recurring, that a party has a right to file successive actions. That's well recognized in the Commonwealth. So the statute...
You can file the actions. The question is, what's the consequence of doing that?
Correct, Your Honor. So we look back to the specific language of the statute. The language of the statute says nothing about whether a second action can be filed, but it says that when an action is filed, a priority lien is created. So in order to accept the defendant's position in this case, the court must read into the statute a prohibition, which the legislature has not seen fit to include in the language of the statute. That is, in order to conclude that a second priority lien or a third priority lien is not created, this court must read into the statute that when a complaint is filed, when an action is instituted to enforce the lien, a 6-month priority is created unless a prior action has been previously instituted and remains pending. That language is set forth nowhere in Section C. This court need not read into the language permission with regard to this question because the permission is set forth in the language itself. This court need not rewrite the statute in order to conclude that the filing of an action perfects a 6-month priority.
Would the legislature create a process that is not only cumbersome, but in some respects impractical, requiring you to do it this way? I mean, if the intent was for the association to have this super lien ad infinitum, why would you have to go into court every 6 months? Why would the legislature make you do that? That doesn't make any sense.
Well, there are two questions there, Your Honor. The legislature did not intend for an association to have an unlimited priority lien, a priority lien ad infinitum. This is clearly a one-of-its-kind statute. There is no statute in the United States that mirrors 183A Section C. But what the legislature did was effectively put an association in a position to protect itself against first mortgages and other subsequent liens. The fact of the matter is this statute puts the association's lien in front of everything except 3 narrow circumstances: tax liens, prior recorded encumbrances, that is before the master deed was recorded, and first mortgages to the extent of 6 months in connection with the filing of a complaint.
So you have the lien.
There is a lien, Your Honor, yes.
You can move to foreclose on that lien.
Yes, well, you can, Your Honor, but it is a judicial foreclosure. So in Massachusetts, the legislature has required an association. It's not non-judicial as a mortgage would be, it's judicial foreclosure. So we have this circumstance where we have this matter in appeal for essentially 8 years, so that this association has not been paid for 8 years because Massachusetts has adopted a judicial foreclosure statute in this context. But to go back to your question,
That takes a long time when it's a judicial foreclosure as opposed to the kind of foreclosure that the first mortgage holder could.
Generally, Your Honor, and certainly in 1992 when the statute was enacted, there is a difference between non-judicial lien foreclosure and
Saying it
judicial
takes
lien
8 years?
foreclosure.
No, just this
No,
case.
in this circumstance, it
Because
did,
you
Your
didn't
Honor.
foreclose.
No, because there have been appeals, Your Honor. This matter has gone up.
Well, you certainly have a super priority lien for the first 6 months, right?
Yes, Your Honor.
There's no question about that.
But that's in this case that's on appeal. So we cannot foreclose on that decision, Your Honor.
The language, I'm just looking for it. Where is the language about that the mortgagee can basically retain by paying the unpaid amounts up to the point where the mortgage is over?
That's found in 2 separate paragraphs in Section 6C, the second paragraph and the 4th paragraph. The mortgagee has a right to pay off a priority lien after it's instituted, and a mortgagee has a right to pay off a priority lien or avoid the institution, rather, of a priority lien by entering an agreement with the association to recognize 6 months priority, and then to agree to pay on a go-forward additional common area expense fees.
Is your argument, at least I think it is, that that language supports your view that you can bring these successive actions? Because why would there be language in the statute about the mortgagee paying forward, if you will?
Exactly, Ron. And it goes even further than that. That paragraph 4 and paragraph 5 both specifically mention priority liens against a particular unit. And what that paragraph 4 does, which was added in 1998, 6 years after the priority lien was created, allows is a bank to avoid and prevent an association from taking further action to enforce its priority liens. And it's the plaintiff's position that that amendment has to have had purpose, that there would be no reason for the legislature to introduce what is admittedly, as Justice Hines points out, an additional complication with regard to the interplay between association and first mortgagee, this rather elaborate scheme that requires a bank to not only recognize a 6-month priority, but to agree not only to pay on a go-forward all association common area expense fees, but also to pay special assessments. That comprehensive provision in the statute provides the only legislative ability of a bank to prevent an association from taking further action to enforce its priority liens.
The part that I don't understand. So if the bank chooses not to do that, isn't its alternative, you had a super priority lien for 6 months and that's it? That's the...
No, Your Honor, because there is no limiting language.
That's what happened here, right? I mean, the bank chose not to do anything.
Correct, Your Honor. And what happened?
A 6-month super priority lien comes in front of its mortgage.
Correct.
And why isn't that just the consequence of the legislation?
Because there is no limitation on the legislation's authorization of an association to perfect an additional 6-month priority. And this gets back to Justice Hines' question. Why did the legislature set it up like this? Well, the legislature didn't give a blanket priority because it did not want to create a situation where the association's lien was completely ahead of the first mortgage. So what this statute does, which is different than any other statute in the country, is requires an association to give notice to a first mortgagee 60 days after a delinquency. And with that notice, the bank is in a position to take action. The bank, the first mortgagee, is in a position to pay off the lien or to compel its borrower to pay off the lien because in most circumstances, failure to pay common area expense fees is a violation of the mortgage. In addition, this statute requires an association to give a 30-day notice to the bank prior to filing suit. And what does that do? It allows the bank to take action before a lawsuit is filed. The bank can avoid the filing of a lawsuit.
So the bank also, because the bank has the right as the mortgagee to bring a non-judicial foreclosure action.
Correct,
Should
Your
it- If what you say is true, that non-payment of these kinds of expenses is a default under the mortgage.
It is in the typical circumstance of default under the mortgage. And in addition, the fourth paragraph of Section C allows a bank to prevent an association from filing additional successive liens. So what this statute does, and why the legislature did it in this way, is so that a bank could prevent an association from perfecting multiple priority liens, and a bank would not be exposed completely to the fees that were accruing at a condominium association. If this were simply a blanket lien, an association could sit on its hands indefinitely, provide no notice to a first mortgagee, and the mortgagee would be subjected without the ability to intervene, without the ability to protect its priority.
So you're saying the bank can put a halt to this if the second or the third time that the condo association brings suit and gives notice, each time the bank is then in a position that it can limit its exposure?
Absolutely, Your Honor. The statute's clear on that. There isn't really a dispute about that. The question is whether or not an association can perfect an additional priority lien in connection with the filing of that successive action.
And under Section 6C, the bank, I take it, can recover all amounts paid, including attorney's fees, pursuant to the enforcement of the lien, or
The bank or the-
arising out of the enforcement of the lien.
Well, Section 6C would not give the bank that
I mean, the
authority.
bank or the,
That really controls the association's ability to enforce, but the mortgage instrument itself, the typical mortgage instrument, would allow the bank to turn to its mortgagor
Okay.
and to collect those amounts from the mortgagor.
I thought that Section 6C also said, though, that in the event of a foreclosure, the bank could pass all of these costs along to whoever buys at the foreclosure sale.
Your Honor, yes, there is, that remedy is built in to the bank's abilities, yes.
By statute. So if for some reason the first mortgagee or the mortgagee is not a bank and does not have the kind of clause that you're talking about, that the first mortgagee can nevertheless recover amounts paid.
Yeah, it is less clear, Your Honor, when the first mortgagee is not an institution and doesn't have the backup instruments. But what the legislature has done here, there has been this analysis of balancing. What the legislature has done here is very different than what has been done in other states. And the fact in 1998 that it added this provision that allows a bank, or a first mortgagee, I won't even call it a bank, a first mortgagee, to prevent an association from taking further action to enforce its priority liens as to a particular unit must be given some meaning. The FHFA, in its amicus, suggests that the only operative language in this statute is the language that defines the 6-month priority that was borrowed from the Uniform Act. But there are pages to Section 6C, which spell out, admittedly, what is a more detailed and a more sophisticated balancing that was adopted by the Massachusetts legislature in 1992.
Yeah. The appeals court referred to the Uniform Condominiums Act. I take it the language that you are referring to is not contained in the Uniform Condominium Act.
Correct, Your Honor. In fact, it's the plaintiff's position that when one compares the Uniform Act, which is now essentially the Uniform Common Interest Ownership Act, to 183A, the only thing that this court will find in common between the two is the definition of the 6-month priority. All the notice provisions, paragraph 4, paragraph 5 of 6C are found nowhere in the Uniform Act. The FHFA suggests that the only operative language is the definition of the 6-month priority, that somehow the legislature's adoption of an additional regime in 1992 is meaningless, that somehow the specific adoption of a provision in 1998 authorizing a first mortgagee to prevent an association from perfecting additional priority liens as to a particular unit are not operative. That is not consistent with well-accepted principles of statutory interpretation. Those paragraphs must be given some meaning. And contrary to the FHA's position, there is no suggestion that the multiple priority liens is a reference to liens collectively possessed by the association, because the statute is very specific. It says priority liens as to a particular unit. Thank you, Your Honor.
Thank you. Good morning, Mr. Johnson, I gather?
Yes,
And
Mr.
you're
Chief
sh-
Justice.
And you're sharing the time with Mr. Britton.
I am. Thank you, Mr. Chief Justice, members of the court. Good morning. May it please the court. I am Michael Johnson, representing Amicus, the Federal Housing Finance Agency. The legislature expressly made condominium association liens subordinate to pre-existing first mortgages, with a limited exception that granted 6 months of the condo association's back dues priority ahead of the first mortgage. Plaintiff wants to invert that legislative scheme. It wants to grant the condo association lien superiority over the first mortgage. My friend Mr. Moriarty let it slip. He says there's no limitation in the statute on the amount of times the condo association
But
can
he-
recycle its lien.
But
And
each,
therefore,
each time, though, the bank gets the opportunity to pay the condo association off and avoid the lien entirely.
and commit to paying the dues going forward.
Or foreclosing
Or
on-
foreclose.
Forever.
Or foreclosing.
So the statutory remedy here is a way not to avoid the lien, but it's to recognize the lien and to commit to paying the underlying expenses
So,
forever.
But
So-
basically, by doing it just once, which of course the statute provides, even on your analysis, can happen, just doing it once, the bank still has the opportunity to avoid having it go down even for the first 6 months by paying it off and agreeing to continue to pay. But may just make the economic decision, it's not worth it. And then it's up to the condo association to just sit and wait until the bank ever gets around to foreclosing.
Well, the legislature established the priority scheme, and the legislature made first mortgages senior to condo association liens, except for the 6 months. And we can see that in the express terms of the statute, in the structure of the statute.
Where does it limit it to once?
It's limited to once throughout the statute, because if the legislature...
It's with one complaint.
Because the legislature said we can contrast two provisions that are very important here. We can contrast the provision granted to homeowners associations, which has subordinate to first mortgages with a 6-month exception, to the provision at the end of Section 6, Paragraph C, Part C, Paragraph 1, that deals with receivers under Chapter 111. The legislature wanted something different. It wanted receivers to have an unlimited priority over first mortgages, a priority with, as Mr. Moriarty said, no limitation. It did that expressly. It knew exactly. And the receiver is someone who
But where-
stands in the shoes of the association.
Where is the language limiting that? You have to bring an action every 6 months, but where's the language limiting it to one?
6C, the second paragraph. A lien under this section shall be enforced in the manner provided. This lien is prior to mortgages described in Clause 1 above, to the extent of the common association expenses based on the budget adopted pursuant to Section A above, which would have become due in the absence of acceleration during the 6 months immediately preceding institution of the action. So
Of
there is
an
one-
action,
there-
action.
Yes, there's one lien, one action to enforce it. The legislature said the condo association gets a lien for all of its back dues. Of that lien that extends, that primes out all the mechanics and material men, everyone else, of that lien, 6 months gets the extraordinary privilege of jumping ahead of a pre-existing first mortgage. That's a balancing of interests. Yes, in the circumstance presented here, someone is going to bear a loss. And the legislature said, homeowners associations are important. They do good things. We agree with that. The legislature also presumably said, Mortgagees are important. They do good things. Providing credit to potential condo purchasers is a good thing.
But
As-
why then, if you're right, you're making an argument, as I understand it, that would be made with respect to the uniform common ownership, whatever it's called, COYA or whatever.
Ukiyoa, yes.
Well, this statute's different, though.
Not in the term that establishes and allows for the enforcement of the 6-month lien.
But it doesn't limit, it says an action. Why does that mean only one?
Well, the drafters of the provision told us that the exact language that Mr. Moriarty says allows multiple actions and an unlimited lien, a stacking lien that primes out the first mortgage entirely, does not and was not intended to allow exactly that stratagem.
But why would a bank then, if it was only subjected to one 6-month priority lien, why would a bank then enter into an agreement to pay all the money in the future?
Well, there are costs associated with a foreclosure. As we know, foreclosures affect the value of the property.
But the bank could just sit and wait.
It puts
I
a
mean,
lease pendants on. No, the bank wants to maximize the value of its collateral. It wants to see that collateral enhance in value. It wants to get paid. Remember, the bank has an interest in maximizing the value here, too.
But it
And
limits its liability that way, right? If it's just one 6-month,
The legislature...
then it just says, okay, fine, that's what's ahead of us.
If
Then
the
we know it.
legislature limited its exposure in that way,
Oh, that's arguable, right?
well, that's what the case is about, but that's what the legislature did. If the legislature had wanted to create, as Mr. Moriarty suggests, an unlimited lien subject to, as he observes at page 38, or as he characterizes at page 38 of his brief, a statute of limitations, they would have just done that.
But here's the thing, how do you square, as Justice Spina was just asking, how do you square it with the provision of the statute which basically says to first mortgagees, you can avoid the lien if you pay it off?
Because
the bank then just says, okay, I know what the 6 months is. If it's limited to one, no big deal.
If it's
But if it's not limited to one, then I've got an incentive to do something.
If it's economically sensible for the bank to make that commitment, they'll do it. That's why the legislature put the
For
language in
one
there.
6-month period? That's ridiculous, isn't it?
No, Your Honor, because if there's equity in the property, it may very well make sense for the bank to say, going forward, I'm willing to take the risk that I'll have to foreclose and recoup these payments out of the value of the property. Where there's,
I take one or the other. I mean, the condo association can recover as a priority lien that first 6 months plus all of their attorney's fees necessary to collect.
Correct.
And that would mean the attorney's fees in connection with foreclosure to collect on the lien.
Correct. So the bank's exposure would be greater, and also the fact of a foreclosure action would affect the value of the bank's collateral. So if the legislature had actually wanted to create this no limitation priority lien, it would have done that directly. It knows how to do it. It did it for receivers.
So if the bank pays off the 6-month lien, pays off the 6-month assessment, and the priority lien disappears, and then the condo owner fails to pay again, does a priority lien arise for that indebtedness?
It's not perfectly clear in the statute. I think it depends on whether the entire condominium association lien has been satisfied. In other words, if the condominium association has been made whole for all the back dues, then arguably the slate is wiped clean. We start over. If the unit owner goes into arrears again, then a second super priority lien could arise. There is an interpretation to the contrary. That hasn't been litigated yet. But I think there is a reasonable position that if the entire arrearage is paid off, the condo association is made whole for its entire lien, slate's wiped clean, we start over, and there could be another super priority lien created.
But has that been litigated under the Uniform Act, that question?
Not that I know of, Your Honor.
Okay.
Not that I know of. I see my time is up. We did make some policy arguments in the brief. I think they're very important. I think I want to thank the court for allowing our brief and allowing our motion to argue before the court. I hope it's been helpful in reaching a just and proper outcome.
Thank you. Good morning, Mr. Britton.
Good morning, Your Honor. I'm going to get right into it. The answer to the question is, does any party dispute a 6-month priority lien? I do. Hotly dispute it with 45-plus pages of my 55-page brief. They can't file multiple suits because of the Rules of Civil Procedure 12b-9. Now, the reason the mortgage company could not pay the fees in this case is in the blue brief, in the addendum, page 5 and page 19 of the addendum. I read it into the record. It says at paragraph 4, borrower shall pay all taxes, assessments, charges, fines, and impositions attributable to the property which can attain priority over this security instrument. Now, I've argued that there cannot be a priority lien here. It must be subordinate. Therefore, with that issue outstanding, the mortgage company could not pay these liens. At addendum page 19, paragraph F, remedies. If the borrower does not pay condominium dues and assessments when due, then lender may pay them. These are not condominium fees. These are homeowners' fees. These fees are not governed by 183A. They're governed by the common law of contracts. The general rule that governs this case has been off-cited by this court repeatedly since 1990 with the Commercial Wharf versus Waterfront case. And that rule is, if a declaration of covenant, easements, and restrictions is filed before the master deed, and in that master deed, a property interest is retained or reserved, in this case, an easement to manage all or part of the condominium, then that easement interest is not governed by 183A. And that rule has been cited over and over again. It doesn't matter whether the retained interest is an easement in gross, as it was in Cashman and CBK, or an easement appurtenant, as it was in the Waterfront case. It doesn't matter, and also Spinnaker is an easement in gross. Or, as it is in this other case that I did not cite in my brief, but is directly on point, is Beaconsfield's Townhouse Condominium Trust versus Zussman, 416 Mass 505. In that case, the retained interest was a 155-year lease. So it doesn't matter what the retained interest is. It could be a future interest, as it was in Quaylor. It can be a 155-year lease, as it is in Beaconsfield, or an easement, and as it is in all the other cases. That interest is not part of the Condominium Act. And as a result of that, it cannot be a common expense of a condominium. Now, the blood rule does not apply in this case. Let's review that and find out why. The blood rule states, from the date of this opinion, a condominium unit owner may not challenge the legality of common expense assessments by refusing to pay it. Now, there's two elements there that do not apply to this case. With respect to these fees, I am not a condominium unit owner. I am a homeowners association unit owner. The concept of dual citizenship is something we all understand. I am a member of Drummer Boy Condominium 2. I am a member of the homeowners association. But just like with federal taxes, I owe to the federal government, state taxes I owe to the state government. And the federal government would not have standing to come after me for state taxes, and likewise, the Department of Revenue would not have standing to come after me for federal taxes. So you must stay in your lane, and the line is clearly drawn at the point of whether the property right at issue is submitted to 183A or not.
Are there two organizations? Is there a homeowners association and a condominium association?
Absolutely, Justice Spina. If you look at page A713 in the record, they are both laid out. There's a homes association. Actually, this case is simple. You can just go by the names. The plaintiff is Drummer Boy Homes Association. The condominium association, which must be identified in master deed, is Drummer Boy Condominium 2 Association. Two different legal entities with two different sets of rights and duties. Now, whether the homeowners association or the condo association is in charge and are assessing fees depend on whether the declaration is effective or not. In this case, the declaration was filed prior to the master deed. It lasted 30 years. It's been extended once. It's still in effect. So all fees are homeowners' fees. And the court said very clearly, the appellate division did, in the Spinnaker Island case, that my contractual obligation to my homeowners association is not governed by 183A. The appeals court said that in Cashin, and this court denied cert, leaving that ruling intact. Now, the court has said in all of these cases I cite in my brief that because it's not part of the common area, it can't be common expenses. Why? What's the definition of a common expense? It's the expenses of administration, maintenance, repair, or replacement of the common areas and facilities. Here, if it's not part of the common area, then it can't be an expense of the common area, therefore it's not a common expense. So we go to the blood rule. What does it say? From the date of this opinion, a condominium unit owner may not challenge the legality of common expense assessments. Well, it's not a common expense assessment. Therefore, it's governed by the common law, and in this declaration,
What is it for? What's the assessment for?
it's for homeowners' fees. In this case,
What does that include?
they're managing the condominium, but that management fee was not, that the right to manage it was not submitted to 183A. It was retained. Because it was retained, all of these cases I cited in my brief say it's not governed by 183A. It's governed by the common law of easements. So because there's no statutory priority lien, there's no statutory prohibition on my counterclaims, under the common law, I get to file counterclaims. That was the holding in Cashin. That was the holding in Spinnaker Island. That should be the holding in this case.
I'm afraid your time's about up, so you may want to.
Okay, one more thing. In Waterfront, the court held that reserved easement interest is not a management contract. As a result, they're not acting as agent for the condo association. Therefore, whatever it is that they're doing has nothing to do with 183A. It's under the common law. And the reason my mortgagee could not pay is because these liens are clearly subordinate to all mortgages on my unit, first, second, and third. And as a final point, I'd like to request leave to file a formal 12B1 motion to dismiss for lack of standing. They have no standing to pursue 183A under the Siegel case, and et cetera. And I'd like to make that formal so the court can address the standing issue.
Thank you. We shall take that under advisement as well as the balance of the case. And I think we'll take a morning break.